Okay, next up, 2023 July PR, question 3. And let's take a look at the call to question. What ethical violations, if any, has Laura committed? Laura, the lawyer, answer according to California and ABA authorities. The fact that it says answer according to California and ABA authorities after the entire call of the question is the examiner's way of saying this entire essay is professional responsibility. Now, if they had 2 calls to the question and answer according to California and ABA authorities was under just call 1 or just call 2, only that call would be professional responsibility. If it was further down the trough and it was under both of them, then that tells you the entire essay is professional responsibility. Okay, so it looks like we have a bunch of paragraphs here, and I assume there's going to be a violation almost in each paragraph. So let's see if I'm right. Laura, the lawyer, is general counsel for Moore Homes Mortgage Company, a California corporation. So to me, that already signifies that who do you owe a duty of confidentiality in the corporation? Who's the client? You have to act in the corporation's best interests. And so if an employee of the corporation comes to you and speaks to you in confidence, you must disclose to that employee, hey, wait, you're not my client. And anything that employee says is not protected by the duty of confidentiality. And you might want to, you have to counsel that employee to seek his own counsel. So those are the things I can already tell that's probably going to come up. Eric is an entry-level mortgage advisor at Moore Homes, and I assume Eric's going to get in trouble or something's going to happen here. Eric approached Laura and gave Laura a package of documents that he obtained through his position at Moore Home. Okay. The documents demonstrates that Moore Home employers are falsifying the financial history of many mortgage applications so they can qualify for mortgages they cannot otherwise obtain. Okay, hold on. So Eric approached Laura. She gave her a package of documents he obtained. They demonstrate that the employees are false. Okay, so other employees. By the way, I worked at a company that did exactly this. Preferred Credit Corporation, also known as paste, cut, and copy. That's what we used to call it because they used to falsify all the mortgage documents. Very common in the industry. Paste, cut, and copy. Okay. The guy I used to work with, I just had dinner with the other day. The documents also show that it was his brother's company, that Mortgage Homes policy to push risky mortgages onto unsuspecting customers. Yeah, that's how the business works. Okay, so they falsify the financial history so they can qualify. Got it. So the banks will loan them the money and they can sell the loans. Got it. Eric confided in Laura that he was troubled to have learned of these practices himself. He confided in Eric that he was troubled to have learned of these practices himself. What does that mean? You have learned of them, that he knows of it or that he's doing it, and wanted Laura's legal advice on what to do. Now, she's not his lawyer. So not his lawyer must tell him to seek independent counsel and explain to him how she acts in the interest of the corporation and that anything he says is not confidential because her duty of loyalty is to the client. The client is the corporation, not to Eric. So she needs to discuss that before it goes any further. Eric said that he has never engaged in these practices himself and does not want Miana. Anyone know how to say the name? Miana? Mortgage Home CEO to learn of their discussion. Well, you can't promise anything here. Laura told Eric she would think about it and get back to him. Okay, so she's violated an ethical rule to communicate. Well, he's not the client, but she does have a duty to others. He's not represented by counsel. She's not his attorney. It's a typical corporate. Let me see here. Let me go to professional responsibility really quick. Okay. Give me a second. Okay. So we know this. A lawyer employed by a corporate represents the corporation. The lawyer knows that a person associated with the corporation is engaged in a legal act that is likely to result in substantial injury to the organization. The lawyer must proceed in the best interest of the organization. Generally, must refer the matter to a higher authority, such as the president of the company. But here we have the CEO, who also is the probably the highest ranking. So you might have to go to the board of directors. So here, when you're dealing with an employee, so clarifying the lawyer's role when dealing with an employee. When dealing with an employee, the lawyer must explain the identity of client that the lawyer represents the organization. Once the lawyer learns that the organization's interests are adverse to the person with whom the lawyer is dealing, the lawyer should advise the employee she cannot represent him, and the employee may wish to obtain his own attorney. Must also explain to the employee that discussions between them may not be privileged. So she failed to do any of that. So let me see if there's so would it be the conflict of interest? One more thing here. I just want to see about okay, it's not a witness, not a person to refrain. Not represented by counsel. Okay. And dealing with an unrepresented person. So in dealing on behalf of a client with a person who's not represented by counsel, a lawyer must not state or imply that she is disinterested. When the lawyer knows that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer must make reasonable efforts to correct the misunderstanding, which she should have done here. She may not give legal advice other than to secure counsel if they know that the interests of that person are in conflict. And it does seem to be in conflict because he doesn't want to get the CEO, Miana, in trouble or to learn about their discussions. Well, the lawyer's, Laura's going to have to disclose that. So we're going to have a tough time getting around that. Okay, so those are the issues that have already come up here. Okay. Laura told Eric she would think about it and get back to him. Eric left all the documents with Laura as she requested. Okay, she doesn't have to return the documents. He's not a client who fired her or anything like that. These are the documents are, these are also not privileged, by the way, because this isn't something that was done. They're not privileged. Let me explain. I can't explain how, but I'll go through it. Laura knows that the practices shown in the documents and described by Eric constitute a crime under state law. Again, this seems to me to go to confidentiality about what to do under situations where, what to do in situations where you have like a crime. Confidentiality, and we all know that one. So do you have confidentiality? Let's see here. Under the ABA, lawyer can reveal it to prevent the client from committing a future crime or fraud that is reasonably certain to cause substantial financial losses to others if the lawyer's services were used to perpetuate the fraud. But her services are not being used to perpetuate any fraud. They're doing it all on their own. So she can't say anything there. And under California, as we know, California has very strict confidentiality rules. So the lawyer, she's not even allowed to say anything under California, even if her services were being used. Okay, because California has, let's see here. Yep. For the most part, the rule in California is the same, except that California does not have an exception for financial crimes, which this would qualify for. Laura also knows the state attorney general is aggressively investigating similar practices by mortgage companies in the state. Although Laura is not aware of whether More Homes has been identified as a target for investigation. That's interesting. I don't know why they put that there. Maybe that has to do with the fact that she should definitely disclose this to the board so that they can rectify the matter as quickly as possible so that they don't get sanctioned. And if they are caught for past practices, at least they can show the mitigating effects of, hey, look, as soon as we've got word of what our employees were doing, we put a stop to this. And so maybe we shouldn't be punished so severely. I think that's probably why that is in there. Would you guys agree? Is that what you saw? People, Elizabeth, yeah? Okay. Immediately after Eric left Laura's office, Laura called, I don't like this name, Miana, and informed her of Eric's visit and about Eric's comments. Of course she did. And she owes nothing to Eric, no confidentiality. Although she should have informed him about that, and that's where she broke a rule. Marian instructed Laura not to do anything with the documents and to give them to Mariana. Wow. So instructed her not to do anything. What is the only thing that Laura can do in this situation? Anybody know? Nika?
Is it the duty to like disclose it to the court?
Nope. Can't disclose it. The rules don't let you because your services weren't being used and California doesn't have that exception. So she can't actually say anything. Marissa, what can she do?
She can report up from Meanne to the
Well,
board.
yeah, she's the CEO, so if there's a board of directors, you can tell the board of directors. But let's assume that Mariana is on the board of directors and says, just keep it quiet, shut up. What now? I mean, yeah, you can go up. So you can go up the board, assuming there is a board. Okay. To the board. Anyone know? She has one option. Forget about the director. Let's just say there's no directors. Yeah, Alejandro, you said it. Where you at, Alejandro?
Stop representing.
I'm sorry, one more time.
Stop representing. The same
Yeah.
thing as you resign.
She can withdraw. All right, fine, I'm out. But here's the thing, and this is one of the things my professional responsibility instructor taught me in law school. Are you really going to walk away from a paycheck? I mean, think about it, how much, and that was like the ethical dilemmas that they were discussing. You've got a mortgage, this is a good paying job, you've got kids in private school, you got a wife to support who's 6 months pregnant with your second and third kid, and this is a really good paying job. And if you read on the company, no one's going to hire you. No one's going to hire you. You might as well stamp that on your resume, unhireable. So it really brings an ethical dilemma in why people do what they do, which I found very fascinating as something to think about. Okay, Laura consulted with outside counsel regarding what to do with the documents. Can she talk to outside counsel? Can she go ahead and bring this matter to another attorney, to somebody else? Absolutely, she can. Now, she must say as little as possible without giving all the, give enough information without revealing the client. Hey, I've got a client who does this. You don't even have to say it's in the mortgage industry. I have a client who is committing, well, within the company, their employees are falsifying certain documents, and the CEO told me to not say anything. What would you do? I think that's, that's saying enough without saying anything. So that's exactly what you are allowed to do. You are allowed to associate with outside counsel. In fact, ABA model rule 1.6. We do something here. I want to see. 1 second. I'm going to. You guys want to click on this real quick? Confidentiality. And this goes to number 7. So what does it say here? One of the things, to detect and resolve conflicts of interest arising from lawyers' change of employment. No, but okay, sorry, that's not the right rule. All right, there it is, number 4. Secure legal advice about the lawyer's compliance with these rules. So there you go. So there you go. And let's see what the comments say about number 4. Authorized disclosure, disclosure adverse. B3. And here's where the comments are. Let's read what it says. A lawyer's confidentiality obligations do not preclude her from securing confidential legal advice about the lawyer's personal responsibility to comply with these rules. In most situations, disclosing information to secure such advice will be impliedly authorized by the law. Come on, get out of there. By the lawyer to carry out the representation. Even when disclosure is not impliedly authorized, it permits such disclosure because of the importance of the lawyer's compliance with the rules. So there you go. That was the secure legal advice about the lawyer's compliance with the rules. That's what they're getting at here. So that's number 4. Okay. So number 4, 1.6 B4. Okay. And based on that advice and against Mariana's instructions, lawyer provided copies of the documents to the state attorney general. She could not do that. That's the one thing she could not do, because that has now breached the duty of confidentiality. And the reason is, even though this is a crime or fraud exception, her services were not being used to perpetuate the fraud. And that is the key here, is your services have to be used, which they weren't. And under the ABA, that doesn't give her the right to disclose it. And as you know, California has strict confidentiality rules, so she breached it there. Okay, well, actually not a difficult essay. If you caught that the services were being used part of the rule, then I assume you did pretty well on this, because everything else is, you know, reporting up to the corporation, explaining to the employee, the duty of confidentiality doesn't apply to Eric. Okay, questions, comments, what do you guys got? What do you think? So far, not a difficult gauntlet of essays that we've gone through. The products liability one, I would say was the most difficult so far, but we still have 2 left. So go ahead, guy. I'd like to hear what you have to say. Comments on this one. Y'all look shell-shocked. Was there a reason?
I also, in addition to the confidentiality rule, I also discussed a little bit on the duty of being competent, because she didn't go all the way, you know, beyond trying to protect her client. And also I discussed, I think,
Well, her client's a corporation.
yeah, but she was kind of like trying to save, I kind of tried to put it like she was trying to, also the duty of loyalty, because she was trying to save more her own interests to not get involved with this, accusing the corporation, I forgot the details of the question, but, you know, like trying, because it doesn't say that she went all the way and report her client.
Well, I'm not seeing it's interesting. Conflicts of interest are tested on almost every single PR essay. I'm not seeing it here. Am I missing something? Does someone else see conflicts of interest that I didn't? Because I don't see any conflicts right now. I mean, her personal interests aren't getting in the way. In fact, she's actually doing everything but the last step where she turned over the documents to the state attorney general. Everything she did was, well, she royally messed up with Eric. So she royally messed up with Eric and the state attorney general, but everything in between, I think she was doing it perfectly. You know, assuming there is no board of directors. I'm not seeing a conflict. Does anyone see a conflict here? I don't. Did you guys discuss it or no? Yvette, did you?
Yeah, I discussed conflict, but I don't remember exactly what I discussed, to be honest, but I wrote down that I wrote conflict of interest.
Huh. Marissa?
It's the duty of loyalty to the corporation. More
That's
home.
duty of loyalty and conflicts of interest are the same. It's the same thing. It's just a
Yeah.
different way. Go ahead.
So that's what I'm saying, is that her client is more home. I mean, that's a straight up duty of loyalty thing right there. Because
How's she loyal to the company?
so she's trying to not allow, she's trying to act in the best interest of her client,
The corporation, yeah.
the corporation. Yeah, but yeah, so
I'm
anyway,
not seeing any
duty of
conflicts.
loyalty.
I'm just not seeing it. I mean, to me, it seems like there should be one, but I'm not seeing it. Okay, give me 1 second. And just one clarification about the fact that Laura provided copies of the documents to the state attorneys general. Under Rule 1.13, Section C, she was allowed to do this without breaching the duty of confidentiality. And this is true even though her services were not being used to, where does it say? Even though her services were not being used to further the violation. So the fact that Laura provided the copies to the state attorneys general was proper under Rule 1.13. And that is when the highest authority of the corporation fails to act or refuses to act in an appropriate manner, then the lawyer can go ahead and report it to outside of the corporation without violating the duty of confidentiality, even though the lawyer's services were not being used to further the violation.